Good afternoon, ladies and gentlemen, and welcome to Khaitan Companies and Singapore Corporate Council Association's webinar today on the digital economy in India, an overview of recent judicial and legislative developments. My name is Karun Cariappa. I will be your moderator for today. Let me give you a brief about Khaitan Company. We are one of India's largest law firms. We have offices in Mumbai, Delhi, Bangalore, Chennai, and most recently we've opened up an office in Singapore. The Singapore-India corridor, as you know, has got immense developments in terms of investments into India. We've got the SIAC opportunity. And in order to cater to all the funds who are investing in India, including in the digital space, we have recently opened up an office out here. Allow me to introduce myself. I am, like I said, I'm Karun. I'm a corporate partner who sits out of the Singapore office. My area of expertise is venture capital and tech M&A and investments and exits. Today, I have three of my stellar partners who are joining me. I have Indruj Rai, who is a partner who is located in Delhi. He is a partner in the direct tax practice group of the firm, specializes in direct tax advisory and tax litigation, and he has vast experience in advising clients, including tech companies, funds, and private equity and venture capital firms on varied matters, including M&A transactions, inbound and outbound investments, and restructurings of businesses. Indruj has also successfully represented domestic and international clients at several litigation fora, including the Supreme Court of India, various high courts in India, and tax tribunals. My next speaker, who will be speaking about online gaming, is Ganesh Prasad, who is a senior partner who is located in Bangalore. He is a partner in the corporate and commercial practice group. He has close to 2 decades of experience advising clients on various complex transactions, including cross-border inbound and outbound M&As, JVs, strategic partnerships, PE funds, general corporate law, employment, white-collar investigations, financing and corporate restructurings with a focus on technology, e-commerce, and the gaming sector. He is also on the advisory board of the All India Gaming Federation and Indian Federation of Sports Gaming. Last but not least, I've got my partner Vinita Krishnan, who will be speaking about digital tax. She is a director in the direct tax practice. She has over 15 years of experience in advising clients on domestic and international tax matters. Her expertise covers a broad spectrum of tax matters, including digital tax, international tax, structuring of inbound and outbound investments, transactional tax, and M&A. She has acted for MNCs on complex cross-border tax matters, such as permanent establishment, income characterizations, digital tax aspects, and withholding tax considerations. She has extensive experience in transactional tax in several sophisticated M&A deals, and her past experience included having worked at Ernst & Young and the transaction tax practice. Now, just a couple of house rules. Before I allow my speakers to start, we will be curating your questions. If you could send your questions on the chat box that you have. Once we are finished with the presentations, we will then ask your questions to the various panelists that we have speaking for us today. Without further ado, I invite Indruj Rai to commence with tax considerations stemming for the intermediary liability guidelines. Thank you.
Thank you, Karun, and hello to everyone. So today we'll be talking about unintended tax consequences for social media intermediaries. They were, if you could just move to the next slide, please. There were these, next one, please. Thank you. So we've had recently these social media intermediary guidelines prescribed by the government of India. We'll talk about their tax consequences. And I'll just give you, to begin with, an overview of what these guidelines are. Then talk about tax principles that are there in India and how they apply to these guidelines. So to begin with, as has been the global trend, different jurisdictions and countries are seeking to have a level of control on the online content that's shared over digital media platforms. India has been no exception to that. The main reason has been moderating content around explicit content around sexual violence, child pornography, fake news, terrorist activities, and affecting vote bank. These guidelines were implemented earlier last year in February 2021. They seek to apply to social media intermediaries, which are basically enterprises that facilitate sharing of content between users online. The rules we'll talk about specifically apply to significant social media intermediaries, which are entities that have user base in India of over 5 million users. The main compliance requirement that's been prescribed by these guidelines is around placing 3 key individuals in India. These individuals need to be full-time employees of the foreign entities. They will have the designation of a chief compliance officer, a nodal contact person, and a resident grievance officer. In addition to this, the foreign entities also need to have an address in India where correspondences which are non-digital can be received from the government organizations. As an overview, what needs to be done by these individuals is carry a level of diligence and proactively moderate the content that's shared over the platform. They also need to identify the originator of the content in case someone needs to be held liable and the content needs to be taken down. We'll take a quick minute to just talk about the exact role of these individuals, because that is what ties into what tax implications that can be there in India. Now, firstly, talking about the chief compliance officer, he needs to be a senior employee of the foreign entity, a key managerial person, and he's overall responsible for ensuring compliance with the guidelines of the Act and can be held liable if there's any contravention. Now, largely speaking, social media intermediaries have been granted immunity under the Information Technology Act because they only act as a conduit. So any content that is there that does not relate to them, has not been uploaded by them, they should not be held liable and will have an immunity, provided the guidelines that are prescribed are strictly followed. The next person is nodal contact person as an employee, who needs to be available round the clock and needs to coordinate with Indian government authorities in terms of moderation of the content on these platforms. And lastly, there's a resident grievance officer who needs to acknowledge any grievance from any user within 24 hours and redress it within 15 days. You also need to action any orders of courts. Now, when we move to the next slide, we'll notice that these guidelines were actually met with much protest by the social media giants. The real reason to challenge was, of course, the level of control that the Indian government wished to exert in terms of what can be displayed or not. And it was viewed as impeding upon right to privacy, freedom of speech, and freedom of expression of different users over these platforms. The cases are still sub judice, but what we've learned is that the government has softened its stand from the initial days. While there's still a level of compliance that is required, largely the government has come out with a set of FAQs. And so long as the intermediaries are following that, the government is not really cracking down on them. So that's been sort of the update in terms of these guidelines, the requirement to have the 3 individuals in India. Now we'll move on to the next slide to talk about the tax implications. Thank you. So when we talk about the tax implications, what may be helpful to know is that these tax implications generally are relevant even for non-digital entities, while they're equally relevant for digital entities. Any foreign entity that does business in or with India will pay tax on its business profits only if it has some form of taxable presence. Now, this taxable presence is judged by 2 different concepts, which are alternate concepts. There's a concept of business connection that applies if the foreign entity is based in a country which does not have a tax treaty with India. And there's a concept of permanent establishment, which applies when there is a tax treaty. Singapore has a very comprehensive tax treaty with India, and we will be talking more about permanent establishment. As a consequence, if there is a taxable presence, either in the form of permanent establishment or business connection, then the foreign entity would pay tax on its business profits at the rate of 40%, which effectively can come to about 43 to 44% with cess and surcharge. The profits that are taxable are only the profits that are attributable to the activities carried out in India by the taxable presence. We'll take some time to just go through to discuss what really results in a permanent establishment. What are the different kinds of permanent establishment? Like I mentioned earlier, these are relevant even for non-digital entities and any foreign entity looking to do business in or with India. Essentially, there are three different kinds of permanent establishment, or three different ways in which there can be a permanent establishment. They can overlap, but to classify, there's a fixed place permanent establishment, there's a service PE, and an agency PE. For a fixed place permanent establishment, the foreign entity actually needs to be doing business through that fixed place in India. There needs to be an identifiable location. That location should be at disposal of the foreign entity, which means the foreign entity has access to that location, and it should have certain degree of permanence. Now we can see with the foreign entities, the social media intermediaries, when they place these individuals in India, all of these tests are likely to be met. There would be an identifiable location from which they'll work. They will have access to that premises, even if it is something like a co-working space. And there will be a degree of permanence because these regulations require such individuals to be based in India on a continual basis as residents of India. The very key part for there to be a permanent establishment is that the foreign entity must be carrying out business, core business activities through that. Now, whether the activities of these individuals employ results in core business activity or not is something we'll just talk about a little later when we talk about general exceptions. Otherwise speaking, certain conduct of the foreign entity can actually result in a deemed fixed place permanent establishment. This is where either the foreign entity has a branch office in India or has a place of management in India. A place of management is generally where the larger decisions of the foreign entities are carried out. The other two forms of permanent establishment are a service PE, which is when the foreign entity has employees in India or has any other individual which works under excessive control of the foreign entity, and those individuals are used to provide services to clients or to group entities. Then there can be a service PE. And the last kind is agency PE, where an individual in India actually has the authority to take decisions that are binding on the foreign entity, so can conclude contracts or negotiates contracts on their behalf, and also helps in securing orders. Now, when we've talked about the three different kinds of permanent establishments, there is an umbrella exemption that's available regardless of what kind of permanent establishment you're looking at. And that is if the activities that are carried out in India are actually preparatory or auxiliary in nature. That is that they do not constitute core business activities. To apply this to the social media intermediary guidelines and the work that will be done by these individuals, it can be seen or probably argued that these individuals, the work they'll do, will per se not be treated as core business activity, even though the work that they'll do is of content moderation, and content moderation is an important, significant part of business of an online platform. But the context that needs to be put here is that it is actually a forced presence of these individuals by virtue of the guidelines that are prescribed. In addition, the kind of content they'll moderate will actually come from either grievances of third parties or directions of the government, and they're actually likely to hinder the amount of content that can be shared otherwise in terms of what they would have chosen to otherwise display. So it could be argued actually it's not in furtherance of business and rather restricting the business in a way by virtue of mandatory requirement of law. Having said that, there are certain considerations to be kept in mind. So long as possible, it should be so that still the content moderation activities of the foreign entities are carried outside India. There's a committee or a board of individuals that takes a larger decision, and it's not just left to the chief compliance officer to give directions to the foreign entity, which are summarily followed. Now, what we've seen with our clients and other entities is that once they decide to place these individuals in India, they just don't want to use them for the purpose of the guidelines because they're paying them hefty salaries. They also use them for other business activities. So you could see these employees also carrying out business development, securing more work, and generally collecting information. Now, it is here where the concerns around permanent establishment actually get heightened. What we've also seen entities do is then they give them a title which is not as prescribed by the guidelines of either chief compliance officer or a nodal officer, but will have a title of chief compliance officer and an operating officer, for instance, because they want these individuals to go represent themselves in the Indian market to procure more work. Now, those are the aspects that will actually attract tax scrutiny and could also result in heightened risk around permanent establishment. If we move to the next slide, we could just talk about the applicability of permanent establishment in terms of a case study. So we've presented two case studies over here, case study A and case study B. Case study A is a simpler set of facts wherein largely the entity is placing these individuals in India only for the purpose of adherence of the guidelines and not really trying to meet other commercial objectives. So here you will have the title of the employees be in line with the guidelines. So the chief compliance officer, grievance officer, nodal officer. The work they'll do will be strictly moderating the content, taking in complaints or directions of the Indian government, and then passing them on to the foreign entity to be implemented. So that, again, like we discussed earlier, is likely to be seen as non-core work, given that it's first mandatory on them by the operation of law, and secondly, probably restricts the amount of content that can be shared on the platform. Lastly, what the kind of presence that the foreign entity is usually seen choose is called a liaison office. Now, liaison office is the extension of the foreign entity. It's not a separate legal entity. It's governed by the foreign exchange provisions and is not permitted per se to carry out any business operations. So that also helps to show that no business activities are being carried out. So with these set of facts, the risk around permanent establishment should be easily mitigated. But what happens is usually achieving the commercial objectives as well. And when you have the employees, as talked about in case study B, having roles and responsibilities much more than what's provided by the guidelines. So you could have them undertake business development, do some marketing, and go meet clientele in India, go meet large corporate houses, represent the foreign entity, talk about the commercial terms of furthering the business, also negotiate them. Now, these are the aspects which could result in a permanent establishment. And it would be important to have a detailed set of do's and don'ts to ensure that it does not. Also, the presence that is chosen by the entity would matter. If you choose to be present in India by having a branch office, which again is regulated by foreign exchange provisions, but permits you to carry out business, you could come under the tax radar of the Indian tax authorities. So case study B is probably closer to an entity having a permanent establishment. Moving on to the next part, we could just generally talk about certain compliances that could still apply in relation to having these individuals in India, whether or not a taxable presence is formed. Generally, when the salaries are payable to individuals who are resident of India by a foreign entity, the foreign entity would have to withhold taxes and pay it to the Indian government. In order to do so, it would also have to procure certain Indian tax registrations known as PAN and TAN. These registrations could take some time, generally about a month on the upper side, so it's helpful to keep the timeline in mind. If there is a taxable presence, then there would be additional tax burden and compliances in India, where tax returns will have to be filed and transfer pricing may also have to be followed. Overall, if just the guidelines are being followed and presence is there in India just for that reason, and with following certain do's and don'ts, the PE risk should certainly be mitigated and it should not result in additional tax burden for the foreign entities in India. At the same time, those individuals can carry out a bit of commercial work as well, in addition to what's prescribed by the guidelines, and it can be well balanced to ensure that also does not result in a permanent establishment. In any case, permanent establishment is a mixed question of law and facts. So it really depends what's done on ground factually. And it's important for each entity to have a tailored list of do's and don'ts of what those employees should do when they're present in India to mitigate the permanent establishment risk. That sums up my presentation. Happy to take any questions that are there during the Q&A. Thank you. Back to you, Karun.
Thanks very much, Indruj. That was a fascinating overview of the intermediary liability guidelines. Now moving on to Ganesh Prasad, who will be talking about judicial developments in online gaming. Over to Ganesh.
Yeah. Hello, everybody. Thanks, Karun. So gaming and the entire segment has actually been gaining a lot of momentum. And as we speak, the one thing which I possibly see in this industry is every month we have at least a minimum of around 8 to 10 inquiries from foreign clients, both law firms and operators alike. So I think I'd just like to sort of take you all through a quick background of the gaming developments which have happened recently. So just to give you some context on the background, the entry 34 of list 2, which is the state list of the Constitution of India, basically confers the power onto the states to govern laws in relation to betting and gambling. States are effectively, states are they have the power to make the laws with respect to betting and gambling. And most states have adopted the Public Gambling Act of 1867 with or without amendments. This is an archaic piece of legislation which is basically a colonial hangover, as I call it. Now, one very key thing which we need to note here is the Public Gambling Act actually excludes games of skill to a large extent. And I think we also, just to sort of keep you, give you a more closer picture, the Supreme Court of India has on many occasions upheld what would constitute a game of skill over a game of chance, which effectively would be a betting or a gambling. Now, there is no central legislation or a law with respect to games of skills, and that's possibly one of the key issues which we are facing in this particular segment. The reason being the states are having the power to make laws in relation to betting and gambling in India. Now, we have one very key legislation, two legislations which came in. One was in Tamil Nadu and another one is in the state of Karnataka. And both of them were akin to sort of cover different aspects, but differently. So, Jungli Games India Private Limited was one of the key, the petitioner before the state of Tamil Nadu, for the Madras High Court, and where they were challenging the Tamil Nadu Gaming and Police Laws Amendment Act, which came in. The state had gone out of its jurisdiction to say so, basically covering the games of skills also, which were actually outside of its purview. And this was actually upheld as being unconstitutional, and this violated Article 14 and Article 19 1G, which was basically right to equality and right to carry on any business or profession in the country. Now, the logic to this was again whether states could actually extend their coverage of betting and gambling on games of skill as well, which actually have been settled by judicial pronouncements and which actually are not under the purview of betting or gambling. And that's what has been upheld. A very interesting side observation which actually came about in this particular judgment was that in case of card games or board games, there is no distinction between the skill involved in the physical form of the activity or in the virtual form. What this meant was that, for the first time, while we are at this point in time seeing increased traffic on online games, we basically never had any kind of a distinction which was drawn earlier between online or offline games. For the first time in this particular judgment, we saw the court actually call out that this skill-based game, it doesn't matter whether it is online or in the virtual, or a physical form, and that was effectively the key essence of this particular judgment. And also, what is not mentioned here quickly, even in Karnataka, I think the Karnataka government has actually passed a regulation which has sort of gone out of its purview in terms of the jurisdiction, in terms, as I call it, where basically they have said that games of skill are outside of the purview, are actually covered, and they're actually restricted in terms of online games. And I think that is also before the Karnataka High Court as we currently speak. Can we have the next slide, please? Yeah. So the other three are actually they're very similar. They basically are with respect. One is the Punjab and Haryana High Court judgment. This is with respect to Dream 11's fantasy business model, where basically it was challenged, and the ruling was that fantasy games has a preponderance of skill, and it is not just a mere game of chance. And I think the same judgment got repeated both in the Bombay High Court, and the Supreme Court has very recently reaffirmed this particular judgment passed by both the High Courts of Punjab and Haryana, and also the Mumbai High Court. In another matter which actually went in appeal before it from Rajasthan, from the state of Rajasthan. And I think that these are some of the key case laws which I would possibly say are very interesting. Now, I think you can have the next slide, please. Yeah. So the way forward, given the increased phenomenon of state paternalism, enactment of various statutes for banning online gaming and quashing of such statutes by the Court of India being unreasonable and disproportionate, it has become important to have clear standpoints on the operability of online gaming. Now, what this also means is that there is no one central kind of a guideline which sort of clearly lays out from the government of India on what online gaming, games of skill or games of chance are, really, because this we have to sort of look at some of the empowered regulations which are there, enacted by the states, or possibly the judgments of the Supreme Court here. So, from a consistency perspective, it is we have worked in the past with the Law Commission of India to sort of come out with a paper to the government of India, and the government of India is at this point in time considering a central framework to regulate the the online gaming, games of skills across. Now, how they would do it is something which we don't have clarity at this point, although they're having certain conversations by the Law Commission with the government of India as we currently speak. Now, in terms of the opportunity here itself, if you really look at the opportunity, what is currently there in the market in online games and in this particular segment, this is just the official estimate. What I see as the unofficial estimate is much higher. As for publicly available information, which is basically KPMG and BCG reports of 2021, India's gaming industry is currently generating $1.5 billion annually in terms of revenue, and it is estimated to grow to up to about $5 billion US by 2025. Now, this effectively requires a much more comprehensive legislation or some kind of a framework by the central government in order for it to sort of be a little more streamlined. We also see, because of the fair bit of ambiguity which is there. Now, I'm not saying it is ambiguous, but I would say it is possibly some of the state paternalism, as they call it, where people have gone a little overboard. Companies are actually opting to sort of look at externalized structures. It could be Singapore as jurisdictions. It could be they actually have the holding company outside, so that the business does not suffer to some extent at least, and and that's a model which I think is increasingly becoming very popular amongst most operators who are offering online gaming, especially in India. Even Indian operators who are actually offering gaming in India are actually looking to sort of establish their operations from outside India. And Singapore, of course, is a preferred destination. In addition to, we have also seen the US for some reason. I don't know for what tax purposes. Maybe my colleagues here on the show can possibly say this, but we see that coming from different perspectives. Basically, they are going offshore and structuring their businesses, even for providing their core business in India. So this, I guess, sums up the gaming developments in the Indian market. I think I will possibly answer any question and answers and take that in the next session. Thank you.
Thanks very much, Ganesh. That's a fascinating journey across how gaming has evolved in India and how the judicial bodies in India have interpreted it. Now moving on to Vinita Krishnan, who will be talking about digital tax. Over to you, Vinita.
Thanks, Karun. Next slide, please. Next slide. So I would be touching upon the concept of significant economic presence. Essentially, SEP is something which determines when a foreign entity would have a taxable presence in India, even though it does not have any formal establishment like a branch or an office or a setup. It's a concept similar to business connection, which Indruj had briefly touched upon. And from April 1, 2021 onwards, in India, a foreign entity can set to have an SEP or a business presence if it fulfills any of the following two limbs. The first basket being if they are in a business where they are owning a marketplace platform and they are targeting an Indian user, and if the Indian user base is roughly around 3 lakh, then they can have a taxable presence in India. Similarly, if they are having any transaction of goods or services or any property, and they are having the transaction with any person in India, and the transaction value in aggregate or in total is approximately $270,000, then there can be a taxable presence in India. And what happens if they have a taxable presence? The business profits of such entities would be taxed in India roughly at the rate of 43% inclusive of surcharge and cess. So it becomes very crucial to determine whether what is the cost of doing business in India, whether your business model attracts any business connection or SEP presence in India. There are certain exceptions, such as if the entity is eligible to claim any treaty relief, then the narrow definition of permanent establishment, as Indruj had also discussed in the first session, that would also be equally applicable, and therefore the wider definition of SEP would not be really relevant. The next exception is if the entity is required to pay India's version of digital tax, which is equalization levy of 2%, then also SEP provisions are not applicable. Next slide, please. Moving on to the equalization levy. Way back in 2016, India introduced a tax called as equalization levy, which was outside the purview of the Indian Income Tax Act. Indian payers were required to pay a 6% equalization levy on payments made to foreign entities for promoting a digital ad. Then in 2020, the equalization levy definition was expanded, whereby a non-resident entity either facilitating any online sales or providing any online service, including supplying any goods to Indian users, are required to pay a tax called as 2% equalization levy. It is interesting to note that the equalization levy is a tax which is outside the scope of Indian Income Tax Act, and neither it is an indirect tax. So the characterization is heavily debated, and whether you would get a credit in your home country is also something which you should factor, because this again becomes a cost of doing a business as a 2% cost. From an equalization levy, it can imply to any sale which happens via any online platform, or whether it is through a website or to a digital operator. And if you are a marketplace provider platform, now whether you should pay the equalization levy 2% tax on the consideration which you receive, which is essentially the commission or the service fee, or it should be on the entire sales consideration, whereby you would be acting as a payment gateway where you collect the payments from the customers and pass on to the owners of the goods. The law as it stands, it says that you have to pay 2% tax on the entire consideration, except where the marketplace platform is facilitating the sales of the resident seller. It is restricted to the fee portion. There are also the way equalization levy is worded, it is quite having a wider impact. any of the limbs happens online, whether it is acceptance of an order online, whether it is booking of the order online, or even if the service is rendered or the goods are supplied online or payment of consideration happens in an online mode, equalization levy has to be tested. So to give you an example, even today sitting in India, if I book a hotel of a Singapore entity, whether the operator based in Singapore is required to pay a 2% equalization levy, because everything is happening offline except the payment which is happening in an online mode needs to be tested. There are exceptions to the equalization levy. Equalization levy is not applicable where a foreign entity has a permanent establishment, then they need to pay the 40% base tax, or where they already are earning an income in form of a royalty or a service fee, which are taxed on a gross basis of 10% in India. In those cases, equalization levy is not applicable. So it is very interesting, especially for a software industry player where they are having a licensing arrangement or a distributorship arrangement with the Indian customers, whether they should pay a 10% tax as royalty or should they pay a 2% equalization levy has to be evaluated depending on the exact business model. In this regard, there was also an apex rule judgment wherein it was ruled that if the software provider is merely doing a usage of a copyrighted article or a sale of a copyrighted article, and it is not involving any usage of any copyright in the article, then in those cases, technically, the royalty should not be applicable and the relevant section is the business income and it should not be taxed in India if they don't have any taxable presence in form of a permanent establishment. So it has to be seen on a case-to-case basis now whether those software provider are using any online medium to transmit or to ensure that the software is reach the hands of an Indian user via an online medium. Then they need to test whether equalization levy of 2% is to be required to be paid. Next slide, please. Also, it is interesting to note in various licensing arrangements, where does the situs of the intellectual property reside is also assuming more and more importance. Right from the day when you engage a service provider or a third-party content writer, whether the IP is situated abroad in Singapore or is it located in India, depending on the functions, risk, and how the document is worded is very, very important. Because the moment the IP is stationed in India or situated in India, it can also have an impact when otherwise a deal is happening at an offshore level where it is a plain vanilla sale of a foreign entity shares. But if the value driver or the IP is sitting in India, there can be a tax leakage. So therefore, even in a licensing arrangement, it is very important to assess right now the impact of a royalty or equalization levy, including any transfer pricing considerations and the situs of IP. In a nutshell, there are various businesses which have been affected by the changes in the digital tax, be it a gaming sector, which Ganesh had briefly touched upon. There are various debating areas, even from an income tax side, whether a OBG platform owner, is he really giving any goods? Is they really giving any service, or does it involve only a pure usage where a user is playing the games and there is no role of service or goods, therefore there is no impact of equalization levy. Even a software provider or a platform as a service provider or a marketplace, a search engine, a subscription-based models, they all need to test whether the impact of digital business. To sum up, whether the cost of doing business should be 2% equalization levy, or whether it should be 10% royalty, or should it be a business income attracting 40%, has to be tested depending on the exact business model. And it is also equally important for the payers because there is a corresponding withholding implication for them. So they need to assess the characterization of income earned by the foreign entities. Second point, which is very important, is a health check and a business reason to determine whether should I come from a Singapore presence and should I be entitled to the India-Singapore Treaty and therefore come out of the rigors of the business connection or the SEP, owing to the general anti-avoidance regulations and the change in the tax treaty provisions. It is very important to have a good commercial reason and a business case and do a frequent health check so as to mitigate any issues which may help or may create an issue while claiming a treaty benefit. The third point is from a compliance perspective, there are certain compliances to be undertaken, whether you have to pay a 2% equalization levy tax in India or a royalty tax of 10% or a business income, whether any tax return needs to be filed in India, whether there are any tax registrations to be obtained, has to be looked into. Lastly, there are changing tax laws in the digital world. Somewhere in July 2021, more than 130 countries, including India, have joined and made a consensus as to how do you tax the profits of a digital sector, which is not so easy as it is so in case of a brick and mortar world. They have come up with provisions such as Pillar 1 and Pillar 2. Essentially, these are the rules which will help to tax the profits of a digital global giant, even in a market jurisdiction. If the global giant is of a sizable nature, say having a turnover of around 20 billion euros and having a profitability of at least 10%, then certain percentage of the global profits can be taxed in the marketplace jurisdiction where they are targeting the users. This is going to be effective from 2023 onwards. Till then, the SEP and the equalization levy looks to be a stopgap measure, and also India and US on a separate note are in talks to ensure that any equalization levy tax paid by a US entity is also given a credit when they pay the tax under the Pillar 1 proposals in a specified manner. So it is very important to assess, and while these provisions are plainly going to impact a digital sector, but the way it is worded, it may also impact a pure physical movement of goods in non-digital space. Say an entity where they are having an internal ERP software usage to ensure the flow of data is proper or flow of software happens smoothly between the parties. Whether they are being impacted needs to be tested. Thank you. Over to you, Karun.
Thanks very much, Vinita. Appreciate it. May I have my other panelists put their cameras on, please? We have a number of questions that have come about. So maybe I'll field the first question to Indruj. How is the permanent establishment issue different where individuals are being employed in India pursuant to the guidelines as against to when individuals are employed ordinarily?
Thanks, Karun. An interesting question. So, nothing changes in law, of course, right? And I think it boils down to what I was talking about generally as an exception and an umbrella exception to permanent establishment provisions, and that is the nature of activities that are carried out in India. Do they constitute core business activity or not? And if it is not, and if it can be seen as preparatory or auxiliary, then it should not be treated as a permanent establishment. The help of the guidelines to make an argument can be taken to say, like I was articulating earlier, that the activities that would be done, if strictly done in adherence to the guidelines, which require these three individuals to moderate content, it's actually firstly a forced requirement by law, right? It's not coming out of a commercial requirement to begin with. Secondly, it would probably hinder the amount of content that can be shared. I mean, if a social media enterprise, its board or committee or sitting outside, decides that certain content does not need to be put out, it, at the end of the day, is getting them more viewership. But because the directions are coming from these individuals in India under the guidelines and they need to reduce the content, so that naturally cannot always be seen in furtherance of the business. So that is the difference, that if you're strictly doing what the guidelines require you to, and the basis and the rationale and the genesis of why they are there, then you could argue that it's not core business activity. For any other individuals who are present in India, I would probably suggest an approach which is reverse, which is you first see what is the kind of work being done. if it's seen as core business activity. And of course, this is a bit of a subjective test. It cannot be as objective always, because now with the integration of tech into businesses and other things, it becomes very hard to really classify to say what is really core and what is not core anymore. But there are some historic cases to help you assess, what has an impact in generating revenues and things to the like. So for others, probably good to do that test and then go back to see, are you fulfilling any of those 3 tests that I talked about for permanent establishment, a fixed place PE, a service PE, agency PE? Are you doing any of those things? But I think greater comfort is drawn usually from what is the nature of the activities. Hope that helps.
No, absolutely. Thank you very much, Indruj. We have a question from Mr. Prasad, which is, how is skill actually determined by the courts when it comes to online gaming? Ganesh, is there any sort of feedback that you can give on that question?
Yeah, so basically, the way courts have actually seen this is, let me take a step back here. It started out sometime when people were looking at Rummy, and Rummy was the first game of which was actually which came before the courts. The one thing which they said was it gambling or was it gaming, which effectively meant that it was a game of skill. Now the courts then, the 1957 judgment, it's as far as we are concerned, it's fairly dated, but I guess that is that continues to this day, because the judges in their wisdom said any game for that matter, whether it's a game of skill or whether it's a game of chance, will have a fair mix of both. You can't sort of say that something is actually only a game of skill or only a game of chance. And this was actually, if you were to sort of look at it in 1957, when this judgment actually got passed, what is Rummy? Rummy technically has a fair bit of skill, but it also has a slight bit of chance. So what the court basically said was, so long as there is a preponderance of game, of skill in any particular game, and the chance element is actually little, then that would actually constitute a game of skill. And that's the only direction that we actually have until now, because and that seems to be possibly the mantra, because every game will have a little bit of both. It's the preponderance of skill which sort of makes it a game of skill.
Well, thank you very much, Ganesh. I think that question was actually from Mr. K.S. Chong, so apologies for that. Now, question for Vinita. In Singapore, we're sort of used to taxation in other jurisdictions. How does India compare with global practices?
So, Karun, it's a very pertinent question in today's era, because India has gone and taken certain unilateral steps, as I had mentioned. So, especially for a digital sector, India has introduced a tax called as equalization levy. That is one thing which India has done. Secondly, whether any licensing arrangement is amounting to royalty or not, it has traveled right up to apex court. And that's how the Indian jurisprudence has been, and how there is a tug of war between the tax authorities. So is there a royalty on a licensing arrangement? And in this context, the Indian domestic law has been amended, whereby even otherwise it is not resulting in any use of a copyright, it may still come within the sweep of royalty. So claiming a treaty benefit becomes very vital. How do you qualify as a royalty or not? And the third thing is, India is also part of the global tax rules, which I had mentioned as Pillar 1 and Pillar 2 initiatives of the base erosion initiative of G20 countries, whereby going forward, profits of a digital entity would be taxed in a marketplace jurisdiction. India is also gearing towards that. So over in nutshell, Indian law, except for equalization levy, rest of the things are in line with the global standards.
That's great. Thank you, Vinita. Now, a question from Mr. Sudeep Das at Walker Chondyok for Indruj. The question is, in slide 8, in case decisions are taken overseas by the board of directors of the foreign entity, depending on the board composition, in case of majority resident directors and they overlap, wouldn't there be a likelihood of exposing the foreign entity to a POEM guidelines in India? And what are your thoughts on that?
Okay, that's a very seasoned question. Just for everyone's benefit, very quickly, a foreign entity can be treated to be a tax resident of India if its place of effective management, also known as POEM, not as pleasant as it sounds, is based in India. Now, a place of effective management is where effective decision making is done. And if a foreign entity is treated as a tax resident of India, then its global profits will be taxable in India. Now, Sudeep, your question is on having majority directors who are resident of India of the foreign entity. So I think there'll be a few things to keep in mind over here. The POEM guidelines firstly prescribe for a de minimis threshold. So whether that is breached or not, number one. Second, the test varies depending on whether the foreign entity is an operating entity or a holding entity. If you're an operating entity, then they will go by the overall decision of the board. And if you're a holding entity, then they can sort of see through the board to see who eventually is taking the decisions. So you're right, there is a larger risk, and optically definitely not a good position to have majority directors who are resident of India. But if you are in such a situation, you can still mitigate the level of risk by choosing to have your meetings on key issues actually in person instead of having digital meetings, and ensuring that those meetings are actually undertaken not on Indian soil. So it would be a factor of a couple of these things, the de minimis threshold that is there, depending on the nature of the activities and how you choose to minute the meetings and where the decisions are being made, and how much do you orchestrate in terms of physical presence or not. Of course, there are limitations that have come because of the pandemic and travel restrictions and things to the like, which make things a little bit more difficult. But it's a genuine concern, and it can be addressed, depending on the facts.
Thanks very much, Indruj. The next question is for Ganesh. Ganesh, we know that governments are sort of controlling activities in the digital space. So what, according to you, are the key phenomena or key issues that should be covered by any framework that regulates online gaming in India? You're on mute, Ganesh.
Sorry. The one thing which I see is a central framework where we have some kind of a guideline which is actually given by the government of India or a central government on what games of skills would be and what games of chance would be, and what would actually constitute and even if there is even some element of because in certain games what we see is that the chance element actually it's around 60%, but for you can say about 40% is the game of skill, or it could be whatever the ratio may be. Now, how do you sort of determine what is actually a game of skill or game of chance? I can always argue when I'm the company that this is actually a game of skill and it's not a game of chance. So I guess some guidelines around this would be actually very important. The second one, I guess we also need some kind. I mean, I think taking from what Indruj had started out with, operators basically have a fair bit of intermediary guidelines around this in terms of, and you have seen a lot of movies in this particular space, which which relates to gambling. Now, there are so many things like chip dumping, which happens in this space. There are operators who actually have both online and offline, methods of actually gaming, which makes it very difficult for the government to keep a track. So some of these are actually coming from experience of the police, and I think also players, and also to sort of keep a level playing field amongst operators, and so that there is a fair bit of, I would say, there's a fair bit of sanctity for amongst operators, in the way they conduct their business and also in the way they sort of deal with money. In some instances, we also saw PMLA, and that is the Prevention of Money Laundering Act, and some of the other provisions which were related therein, which were applied to some of the operators in terms of because they were just players who were outside, who were actually outside India, and they were actually they thought that sending money from outside India, or from inside India to outside, actually resulted in it was akin to some kind of a match fixing. So on these lines, there are actually a fair bit of rules and regulations which can be framed, and it would be better. It would be important for the government to sort of look into this.
That's fascinating. Thank you, Ganesh. Next question is for Vinita. What about software and other licensing arrangements? Are they also taxed according to in the same manner as you would for digital businesses?
Yes. So Karun, in terms of a software provider, we need to first check that are they giving any licensing? What is the form of licensing? Is it a one-time license? Is it a complete assignment, or it is an annual licensing arrangement with the Indian users? And if it qualifies as a royalty, it would be taxed in that way. And if not, what is the medium through which they are selling those software to Indian user? Is it coming in any online medium, or it is coming in a totally offline mode? That would determine the taxability, whether it should be as an equalization levy or just as a business income, no tax in India. And interestingly, we have also seen in many software sector where there are large MNCs, Singapore-based MNCs, and you have also founders who have started their base in India, and eventually they would have grown out of India for expansion and business needs, where they have set up the presence in Singapore. Now, how do you ensure that the intellectual property is transitioned properly, or the IP is actually in Singapore, is something which needs a very careful assessment, and you should have a good transfer pricing arrangements in place to ensure that the IP is developed while there are services which are taken from India, but they are merely an executor, and the IP is actually owned, and the risk and rewards are there in Singapore.
Thank you very much, Vinita. With that, ladies and gentlemen, I think our time is up. I thank you very much for spending your valuable lunch hour with us at Khaitan & Company. We also would like to thank the Singapore Corporate Counsel Association for partnering with us in presenting this webinar. We will be sharing the presentation deck to your email addresses for all those people who have registered with us. Should you have any questions, or for all those unanswered questions that we've received, please feel free to reach out to either of us, any of us, and we will respond to you as quickly as possible. And with that, I wish you a good rest of the day, and thank you very much. Bye-bye.
Thank you, Karun, for being a great moderator.
Great.
Thank you.
Thank you.